So guys, yes, you. Welcome back to WHAAT TV. This is Ace, and man, we gotta talk about it. There's a lot of historical things going on right now, and from the migrant situation to inflation, housing crisis, I mean, there's just a lot going on. But none other than the historical things that's going on is the situation that's happening in Denver. If you don't know, Denver has moved to try to take Trump off the 2024 election, which is coming up, yes, this year. So right now, guys, right now as we speak, the Supreme Court is overseeing this case, which is a historic case that's going to take place. And man, I'm telling you right now, Denver, if this situation goes bad, if somehow Trump is taken off, man, be prepared for about 10 bus loads, 10, 50, 100 bus loads of migrants. 100. I don't know. For right now, I'm going to say 50 buses of migrants. I don't know if you got the over or under on that, but if Trump is somehow taken off the ballot, trust me, Republicans will have their revenge, and Greg Abbott, he's already on top of that. So trust me, migrants will be coming to your front door if Trump is somehow taken off the election. I'm gonna leave you with that. We have to take a look at the sanctuary cities that's dubbed around across America, including New York, Massachusetts, New Jersey, Chicago, of course, California, DC, Oregon, Washington, and now we are talking about Colorado. Yes, we are talking about Colorado. They're trying to take Trump off the ballot, and man, it ain't looking good. It ain't looking good. Let's just jump right into this video so you guys could take a look for yourself.
Hi, I'm Diane Macedo. Let's get right to our top story. The Supreme Court is set to hear arguments over whether former President Trump can be blocked from the ballot for his role in January 6th. The 14th Amendment bars anyone who's previously taken the oath of office from holding office again if they've engaged in insurrection or rebellion against the Constitution. A watchdog group representing voters in Colorado sued, alleging Trump's actions surrounding the attack on the Capitol breached that clause, and the Colorado Supreme Court agreed, removing Trump from the state's ballot. Similar efforts have also unfolded in more than a dozen states, with 2 blocking Trump from their ballots and others allowing him to stay on. Now the U.S. Supreme Court could decide once and for all whether the former president is eligible for re-election. Senior national correspondent Terry Moran joins me outside the Supreme Court now, along with ABC News executive editorial producer John Santucci and ABC News Supreme Court contributor Kate Shaw for more. John, let's start with the stakes here. How significant is this, and what is at stake for the former president in this case?
Well, listen, the reality is if Donald Trump is thrown off the ballot in one state, could it be something that gets repeated in other states? And you mentioned right there at the top, 34 other states have had situations like this, that voters, party officials, others have filed efforts to get Donald Trump off the ballot, haven't been successful outside of Colorado or Maine at the moment. And Colorado is the first test case that is gotten to the Supreme Court at this magnitude. We haven't had a case like this, Diane, since Bush versus Gore in 2000's election. So to think that Donald Trump's possibility of being thrown off a ballot is going to go before a Supreme Court, which we should remind our viewers, 3 of those 9 judges were appointed by Donald Trump. So in a world that his judges, as Donald Trump refers to them, could be judging whether or not he's on the ballot or not, it's historic.
Terry, you covered the Supreme Court's pivotal Bush v. Gore decision in 2000. How do you think this compares to that?
It's very, very different in several ways. Well, one, There were off-ramps for the Supreme Court in Bush versus Gore. They did not have to decide that case and that presidential election awarding victory to George W. Bush. There were still votes being counted. There was a federal law that was designed to take care of conflicts and arguments over the exact thing that was happening in Florida. But the Supreme Court felt that because of the timeline and their own sense of judicial supremacy, that they had to decide that case. It really injured the court's standing with the public. And in this case, there's no off-ramp. It's up to them. They have to decide this case regarding Donald Trump. The other thing, it was a more innocent time. One cannot imagine the court stepping in and doing something like that today, after January 6th, after all this country has been through. It was a very different time and a very different case.
Kate, what will the justices have to consider here? And will they need to determine whether Trump engaged in insurrection in order to rule?
There are, at least a dozen distinct legal questions that the court could discuss today, answer in the opinion it finally issues. Is the presidency even an office under Section 3 of the 14th Amendment? Did Trump previously take an oath? Is the presidential oath different from other kinds of oaths officials take? And critically, Diane, the question you ask, was January 6th or Donald Trump's involvement in January 6th an insurrection? Those are three of the many questions the court, I think, will grapple with. Another is whether this part of the Constitution requires Congress to pass a statute to actually implement it, or whether it has force on its own. And the way this case is set up, the challengers, the ones who are trying to keep Trump off the ballot, essentially need to win each and every one of these distinct legal questions. If Trump wins one, he very likely will prevail, and the court will reverse the Colorado Supreme Court, meaning he can appear on the Colorado ballot. Depending on how they write the opinion, that might not resolve the question for the rest of this year and for all time. It might be narrow, but it's a case going in that the advantage is certainly with Trump given the number of legal questions, and yet I think there's a very strong argument and a pretty broad agreement, though not unanimity among historians and scholars, that the argument for keeping Trump off the ballot is a very strong one on the merits.
Wow, you heard it. So I'm just going to talk about two of the biggest things that's tackling this situation and that the Supreme Court is going to be looking at. Can one state decide who should be on the ballot as president, or who can impact presidency that will impact other states? So if you're in Tennessee, if you're in Florida, wherever you're at, Chicago, should your state be able to just take the president, a candidate off the ballot, which would impact the presidency for the United States, for other states? I mean, if we do operate under federal law, right? So if something happens, if one of these migrants cross in and out of states and doing crime, or if there's different things happening, guns crossing over, different activities, tragic storms, they're in Colorado. Colorado could get hit with a tragic storm, things of that nature, and they're going to need federal funding, federal aid. So can they then decide who they want to be the president when it's a United States? So that's going to be one of the most important things that they're going to be looking at. Should one state be able to impact the entire outcome of the presidency? And they're also going to be looking at the facts if the actions that were done on January 6th was actually can be ruled as an insurrection. Let's take a little bit more and try to hear a little bit insert from the case itself.
Suggested is that there are
or can they enforce it against the president? Those are all three different questions in my mind.
And the answer to all three of those questions turns on whether this court agrees with the holding of Griffin's case. If Griffin's case is the proper enunciation of the law, then a state cannot do any of the things Your Honor suggested unless Congress gives it authority to do so.
So a non-presidential decision that relies on policy doesn't look at the language, doesn't look at the history, doesn't analyze anything than the disruption that such a suit would bring, you want us to credit as presidential?
Because Congress relied on Griffin's case when it enacted the Enforcement Act of 1870 and established...
So, Mr. Mitchell, if I may interrupt, but just to clarify, I mean, this sounds like your reply brief, where it sounds like you're not making a constitutional argument, you're really making a statutory preemption argument. And is that what you're doing here? You're not saying that the Constitution gives you this rule. It's the kind of combination of Griffin's case plus the way Congress acted after Griffin's case?
Yes.
That gives you the rule?
That's exactly right, Justice Kagan, because we have implementing legislation. Congress took up the invitation provided by Griffin's case and established writs of quo warranto in the 1870 Enforcement Act, later repealed them. The only enforcement legislation that's currently on the books is the Insurrection Criminal Statute, Section 2383. And when Congress made all of these decisions, the initial enactment of the Enforcement Act in 1870, the repeal of the quo warranto provisions in 1948, all of those were made with Griffin's case as the backdrop.
Please.
Well, the understanding was that these congressionally established remedies would be exclusive of state court remedies. So there's not an express statement of preemption in these statutes, but there didn't need to be because Griffin's case provided the backdrop.
And if I could just understand the argument a little bit better, suppose that we took all of that away. You know, suppose there were no Griffin's case and there were no subsequent.
Now, she's gonna ask a very important question because they wanna see if they took away everything that they're trying to go on the insurrection. And this is my question to you that I'm posing. Should one state be able to impact the outcome of the presidency of the United States? Should one state have that power?
Congressional enactment, what do you then think the rule would be?
So just as a matter of first principles without Griffin's case, it's a much harder argument for us to make because normally, I mean, every other provision of the 14th Amendment has been treated as self-executing. What we would argue, and that's hypothetical that Your Honor has suggested, is that there are practical considerations unique to Section 3 that counsel in favor of a rule similar to what Chief Justice Chase spelled out in Griffin's case. And it goes to, I think, the policy concerns he talks about, where this was a case, Griffin's case involved a convicted criminal who was seeking a writ of habeas corpus on authority through
proportional, and we would get in.
Sociology expert who would contradict Professor Simi.
Should these considerations...
Just bear with me. I'm going to try to find where they're discussing should one state impact the outcome of all other states.
Vision governing term limits.
Yes, U.S. term limits against Thornton. Maybe.
Right now, they're just battling the argument of was the situation on January 6th enough to be considered an insurrection, and should that be applied to the laws governed to take Donald Trump off the ballot? You guys could go and hear some of this for itself, but I just want to...
Through enforcement legislation creates a mechanism by which the insurrectionist issue is to be determined by some entity. It could be the legislature. In the case of an elected member of Congress, each house has the ability to judge, ban all insurrectionists from holding office, regardless of whether they...
All right. I'm trying to find...
Not qualify, presidency may or may not qualify as an office under the United States. Your principal argument is that the president is not an officer of the United States, correct?
Yeah, I would say it a little more forcefully than what Your Honor just described. We believe the presidency is excluded from office under the United States, but the argument we have that he's excluded the president as an officer of the United States is the stronger of the two textually and has fewer implications for other constitutions.
Bit of a gerrymandered rule, isn't it, designed to benefit only your client?
I certainly wouldn't call it gerrymander. That implies nefarious intent.
Well, you didn't make it up. I know some scholars have been discussing it, but just so we're clear, under that reading, only the petitioner is disqualified because virtually every other president except Washington has taken an oath to support the Constitution, correct?
That's right. Every president, to our knowledge, every other president. John Adams might also be excluded because he took the oath as a vice president, which is not an officer. But yes, President Biden would certainly be covered. He took the oath as a member of Congress, and that's true of every previous president.
Would that be true if we were to hold more narrowly in a reversal, that it's not Section 3 that's at issue, but Thornton and others, as to whether Section 3 can be enforced by states against the president.
That would extend to every presidential candidate, not
Exactly,
our client.
not just
That's
to
correct.
yours.
Yes.
Okay, thank you.
Justice Kagan?
And if I could just understand, I mean, given that you say you don't have a lot of evidence that the founding or the generation that we're looking at is really thinking about office versus officer of the United States, I mean, it would suggest that we should ask, is that a rule a sensible one? You know, if they had thought about it, what reason would they have given for that rule? And it does seem as though there's no particular reason, and you can think of lots of reasons for the contrary,
Right.
to say that the only people who have engaged in insurrection who are not disqualified from office are presidents who have not held high office before. Why would that rule exist?
I don't
All right, guys, I'm going to cut that short. You guys can go and find this on the Supreme Court. Just search for Supreme Court Trump ballot case, and you could hear the whole thing. But what I really wanted to ask you guys, and I was trying to find the excerpt from it, do you think that one state should be able to impact the outcome of the United States presidency by taking a candidate off the ballot? Should your state be able to take a candidate off the ballot? I mean, what? Things that make you go, what? Listen, Denver, man, you're a sanctuary city. That's what we're calling you guys. And I mean, be prepared, because if Greg Abbott hears that Donald Trump is not on that ballot, oh man, he gonna fly, send boats, he gonna ship them, he gonna send them through on a train, plane, car, bus. Migrants will be coming in droves, man. Listen, pay attention. They ain't gonna like it. They ain't gonna like it one bit. I'm telling you, if Trump is off this ballot, yeah, you already know. Greg Abbott, he ain't gonna like it. There's gonna be some revenge for that. But on this situation, just by getting Trump off the ballot in the first place, that looks like to be a win for the Democrats. And man, they have to take their wins while they have them, because I feel like, I don't know, these Republicans, they might be geared up for war, and we're going to take a look into that. Soon, guys, like, subscribe. We're going to be taking a look into what really brought us here. What really got us here? We know that Venezuela, there's a lot going down there, inflation, all the things that they're struggling with, crime, and which is driving people to come here. But domestically, what has really got us to this point where migrants are engaging in crime, getting away? We have a problem at the border. What really kicked this thing off domestically between the Democrats and the Republicans? We're going to take a look at that. Video coming soon. Big video coming soon. Like, subscribe, share. Again, WHAAT TV.